Hi friends, I'm immigration attorney Christian Alvarez, and this video is not for the faint of heart. We will be talking about everything there is to know about the I-601A waiver. So buckle up and let's get started. I chose to do this video really because I am a member of a lot of Facebook groups that discuss this waiver, and a lot of people that perhaps are not working with their attorney, or even those of you that may be working with an attorney, have a lot of unanswered questions. And so I decided that I want to address the most commonly asked questions, and if there are still any questions in regards to this program, feel free to put a comment below with your question, and if I can, I will be happy to answer it for you. If you want to have your case analyzed, you can also visit my website, alvarezimmigration.com. You can book an appointment with me or with my associate, and we're happy to discuss with you your case in more detail. My associate and I, we made a video in Spanish, and it's our most commonly viewed video. So we figured we will also do one in English, and for those of you that may be interested in learning about this program. So first of all, what is the I-601A waiver, right? This waiver is available for those individuals that have been petitioned by either a family member or a company, but cannot get their green card here. Now, there are a lot of reasons why someone may not be able to get their green card within the United States. There are some that entered the United States without a visa, or there may be some that are entered with a visa but overstayed that allotted time, and they started to accumulate unlawful presence. So if you entered the United States and accumulated unlawful presence and don't qualify to get your green card in the United States by means of an adjustment of status, you may have to go outside the United States into your home country and interview there. If someone entered with a visa and married a U.S. citizen, very likely you qualify to adjust your status here, and you may not need this waiver. If you entered without inspection and are married to, let's say, a U.S. citizen, or you have a U.S. citizen parent or a permanent resident parent, you may, and this person petitions for you, you will need, very likely, to go abroad because you entered the United States without inspection. So this is a very general answer, but the most common scenarios that we've seen for cases that do the I-601A waivers are people who entered without inspection, or people who are married to a permanent resident, not a U.S. citizen. Even if they came in with a visa, they need to interview abroad because they accumulated unlawful presence, and the U.S. doesn't allow you to get your green card in the U.S. if you're married to a permanent resident. Even if that person petitions for you, if you have unlawful presence, you can't adjust your status here. There are people who have come in with a K-1 visa, and maybe that relationship didn't work out, the person didn't get a green card through that relationship, and they're now in a new relationship. The K-1 visa is very restrictive, and so the person needs to consular process. Another very common scenario is for individuals that have come in with a crewman visa, which is like a C1 or a D1 visa. You came in working in any sort of boat, and you may have been given an I-94 card, but that's still not enough to be able to get your green card here. Even if you have a U.S. citizen wife, you may need to interview abroad. And this waiver, what it essentially does is that you're asking USCIS to forgive the unlawful presence you had in the United States before you leave. And a lot of attorneys don't explain, why do you need this waiver before you leave the United States? Because the rule is that if you have accumulated more than 6 months of unlawful presence, the moment you step out of the United States, you trigger what is called a bar. You trigger a punishment. If you've been here unlawfully for more than 6 months, the moment you step out, you trigger a 3-year bar. Now, if you have been here more than 1 year, you trigger a 10-year bar. What does a bar mean? A bar means that you cannot get a visa or an immigrant visa or a non-immigrant visa, you cannot get a visa to come back to the United States for that time, 3 years or 10 years, without getting some sort of pardon or waiver of that requirement. So it's important for you to understand the I-601A waiver is very specific. The only thing it forgives is unlawful presence. If you have been here in the U.S. unlawfully, accumulating unlawful presence, you will need that waiver if you must interview abroad. If you can somehow get your green card within the United States and adjust your status here, then you do not need this waiver. Now, the important thing about this waiver is that, like I mentioned, it only forgives unlawful presence. It doesn't forgive if you have had a criminal conviction. It does not forgive if you have perhaps brought in a child or a family member of yours unlawfully or facilitated their entrance unlawfully, or if you have been apprehended at the border and given an expedited order of removal, meaning a deportation order. So there are a lot of factors to look at. I want to talk about the I-601A, but please make sure that you check with an attorney just to ensure that this waiver is really the one you need, okay? If you've already spoken to an attorney and they told you you need an I-601A waiver, then you're good. So we talked about who needs a waiver, right? People that need to interview abroad, people that cannot get their green card here. But how do you qualify for this waiver? So in order to qualify for this waiver, you are going to need either a U.S. citizen spouse or parent to demonstrate that to the government, to USCIS, that they will suffer, did I say U.S. citizen or lawful permanent resident spouse or parent, to show to the government that they will suffer extreme hardship if the foreign national, or if you're the one interested in the waiver, they're gonna need to show that they will suffer without that foreign national or without you, if in case that visa gets denied. So the qualifying relative is very important. I think the most common question we get is, I have a U.S. citizen child petitioning for me and they are over 21. Can that person also be my qualifying relative? And the answer is unfortunately no. Your qualifying relative can only be a U.S. citizen or a lawful permanent resident spouse or parent. Those are the only two relationships or relatives that can qualify you for this waiver. I want to take a step back and explain one commonly misunderstood scenario. The waiver is only the second step in a case, right? You can have a petition filed for you by either your spouse, your parent, or even your child, or even a company. You can have an employer file a petition for you. That's totally fine. That first step is called the either I-130 alien relative petition or the I-140 petition for an employee. So you need to have either one of those petitions approved and for this application to be sent over to the National Visa Center, which is an agency that starts to process applications to get them ready to be interviewed abroad. Or so what they do is National Visa Center, they grab your file and they say, okay, this application, this I-130 approval has been sent to us. We're going to prepare the folder to send to the consulate. And the consulate can be any consulate in the world where the foreign national is either a resident or has lawful permission to live there, or is a citizen of that country. Okay. So once you get that I-130 or I-140 petition approved and sent over to the National Visa Center contacts you or contacts the person in the contact people in the I-130 application, and they say your case is now at the National Visa Center. Here are 2 invoices that you need to pay. So I hope I haven't lost you yet. Once you receive this email with the invoices, you can log into this portal called CEC, and I will put the link down there. Put in your case number and your invoice ID number, and make two payments. The first payment is going to be for the immigrant visa, and the other one is going to be for the adjustment of status. For the affidavit of support. Both payments are about $445, and when you submit these payments, you will put that receipt notice or the receipt for those paid, these two paid forms or paid invoices, along with, they're going to go with your I-601A waiver. So, all right, maybe I went on a little bit of a loop there. I can continue talking about this waiver for a long time because this is really like the most common waiver that we work on in our office. So a very common question that we get is, can my deceased spouse or parent be my qualifying relative? The answer to that is, it depends. They can be your qualifying relative for the I-601A waiver if they filed an I-130 for you before this person passed away. If they did not ever file an I-130 for you, unfortunately, they cannot be your qualifying relative. And I have seen many sad instances where people are misinformed and they believe that they can still use a spouse, a deceased spouse or parent, as their qualifying relative, even if that person never filed the petition for them. And unfortunately, that's not correct. So please make sure, if you are filing an I-601A waiver and you have a deceased qualifying relative, that you have, if this person didn't file an I-130 for you, that you have another type of qualifying relative to take their place, or you have multiple qualifying relatives for the I-601A waiver. Now, what happens if they did? If someone says, well, my spouse filed an I-130 for me, and when that I-130 was pending, he or she passed away. How can I show that this person is gonna suffer extreme hardship if they've already passed away? Well, immigration has released a memo, and they talk about this scenario, and in this scenario they say that hardship is going to be presumed. If the person filed an I-130 for you, or if an I-130 was filed, they will presume extreme hardship, so you don't really need to submit a lot more evidence to support hardship, right? I know it's kind of like, it seems a little bit weird, but remember, USCIS has stated that they will presume extreme hardship. You just need to show perhaps what factor, why you merit this discretionary waiver to be granted. Or if you have any family member here, we can talk about that in the next step. The next step is going to be a little bit of the more of the meat and potatoes of this video, and it talks about what factors does immigration evaluate when taking into consideration whether or not to approve the I-601A waiver. So let me see if I can move here. Oh, here we go. All right, so this is where we really get into the factors. When someone says, okay, I've gotten to the I-601A part, I want to know exactly what type of evidence I should be submitting in this packet. The first thing you need to submit, besides those paid invoices from the NVC, is you should submit an affidavit in support, meaning a letter to USCIS written by the qualifying relative. The affidavit of support is very important because the qualifying relative needs to tell immigration exactly how they will suffer extreme hardship if your visa is denied abroad. And extreme hardship, the definition of extreme hardship is more than regular separation type hardship, right? So immigration, what they say is, we understand that there is hardship that will be suffered if the visa is denied. We know that, right? But your hardship needs to be more than normal. It needs to be extreme in order for us to approve this waiver. And I gotta be honest with you guys, from when this program was first made available to now, the program now has been existing for about 7 years. from when this program started to now, immigration has been getting more and more strict. They have scrutinized applications more and more. I remember in 2013, 2014, these types of cases were easily approved, and now we really are fighting tooth and nail with every application. And so you need to be careful in selecting the evidence. You need to be careful in drafting a very, very detailed affidavit that explains what type of hardships you will suffer. This is actually an anecdote that we're living now, or I want to share something with you. I have a client, or I had a client a few years back. We did his I-601A waiver, and he wanted a copy of his immigration file, which he's entitled to, and he got a copy of the waiver we sent to USCIS, and he shared this waiver with a family member of his, so that this family member can basically kind of like copy a similar format and send the waiver on her own. And I'm sharing this with you because and especially not if you've made it 17 minutes in through the video, I'm sharing this with you because I want to make sure that what this person does doesn't repeat your story, right? So what this person did is they basically copied similar, like a format, and they just sent the case on their own. But when my associate, and then immigration sent her a notice of intent to deny, meaning they sent a letter saying you haven't like proven anything and we are intending to deny your case. Not just that, the information you have submitted to us contradicts, there's contradicting statements. And so my associate and I, we were pretty shocked, to be honest with you, that, you know, somebody tried to copy our work, and then this person got like freaked out and came to see us and said, look, I know you did a really good job with my cousin's case, and now I want you to help me fix the mistake I made. And seeing the errors that were made in this self-application, it was just really like heartbreaking, because this person actually has a really good case. They have a long history of health problems, of like every factor we're going to discuss in the next few minutes. Like every factor I discussed with you, this person had, but the way they wrote the affidavit was really poor. I don't think that they understood, you know, what we had done for our client. You know, when we work with our client, is not simply write something and send it out, right? In our office, when we sit down with a client, we take multiple appointments to help them draft this affidavit, right? So with my client, what we did, we sat down with his wife, who was a qualifying relative, and we spoke to her for at least 10 hours in drafting this affidavit back and forth, you know, helping her, making sure that immigration gets the entire picture of your life, right? They need to know like everything, and how this hardship that you will be suffering is not just necessarily connected to the immigration matter, but if you have had any sort of like mental health problem that connects to something even before, mental health problems you've had before you even got in this relationship, it's important to explain to immigration, hey, I'm not just saying I have mental health problems starting today when I need a waiver. I have been suffering this from the past. That's very important to show, right? So, you know, sometimes seeing someone's affidavit and just thinking you can do it yourself, it's not the same if you're not really armed with the knowledge of the law. What does the law require? And what does this sentence mean in connection to the regulations, right? So let's take a look at the factors that immigration really looks at. And then I'm going to tell you how my office has applied these factors in other cases, like what evidence we have submitted in each case to show that someone has a problem. So I am submitting, so this is an attachment that USCIS had sent to someone that hired us to do their 601A, like after the RFE was sent out. We have people come to us when they get a notice of intent to deny, once they get the RFE. The best thing is to start clean, you know, like a clean slate. That way we know exactly what happened, and every piece of evidence we submit with the affidavit, like nothing is in, in contradiction. But, we help everyone that comes through our doors. So, so these are the factors that immigration looks at. And this is coming straight from USCIS. And it says right here, factors USCIS considers when determining extreme hardship. Hold on a minute. Factors USCIS considers when determining extreme hardship include but are not limited to. So now some of you may say, well, how do I explain these factors, right? Well, USCIS wants to know how will your qualifying relative suffer if you either live separately or if you go live with them in their home country, okay? So if the qualifying relative is a spouse, that's like most of our cases, the qualifying relative is a spouse. How will you live if you have to go and live with your spouse abroad? And how will you suffer if you have to go to live with your spouse abroad because they denied their visa? Or how will you suffer if you have to stay here, separated from your spouse, right? There are many ways you can approach this waiver. You can explain, you can say, well, I have my life here, I have my family here, I have my career here, I'm the U.S. citizen spouse. I cannot go abroad. If my spouse's, visa is denied abroad, unfortunately, we're going to be living separated. This is how we will suffer. This is how I will suffer by being separated from my spouse. You can explain only the separation scenario. You can explain, well, I would be able to move to my spouse's country, but I would suffer this way, this way, this way, and this way. So what immigration states is you can choose the most likely scenario and explain how you will suffer that scenario, or you can, and you have to explain why the other scenario wouldn't be something you would do. If you say, well, I would go and live with my spouse abroad, you have to explain why you wouldn't be able to stay here. Or you can just explain both. You can say, this is how I will suffer if I have to go live abroad. This is how I will suffer if I have to stay in the United States, separated from my spouse. Let's take a look at the first factor. And to me, this is the most important factor to really discuss. Oh my gosh, I'm terrible at writing with this thing. Let's just delete that. So the first factor is going to be health. When we talk to our clients about this factor, I always ask the qualifying relative, what sort of health problem have you had in the past? And when I say health problem, I mean everything. And here USCIS says ongoing or specialized treatment required for a physical or mental condition. We should also discuss the availability of such treatment in the country of abroad, in the foreign country. Oh, sorry, let me close this out. The anticipated duration of the treatment, whether the treatment is going to be, and whether the problem is something chronic, meaning ongoing for a very long time, or acute, meaning short term. All right. What type of examples are the most common scenarios we file here? For health, we really talk about, we really like to show any proof of mental health problems. If you are a parent or you are a spouse of someone that needs to do this waiver, and you have gone to see a therapist in the past, you have suffered panic attacks in the past, you have gone to see a counselor in the past for any sort of, stress, PTSD, postpartum, any depression, you need to make sure that you are upfront with your immigration attorney and you let them know, I suffer from PTSD, I suffer from anxiety or depression, and this is something that I've been going through for many years, and I know that this will really, hurt me if I have to be separated from my spouse or if I have to go live in another country, right? Health is very important. Mental health is a very big factor that we look at, because the reality is that separating sometimes reawakens a lot of mental health issues that the qualifying relative has already been battling for many years. Another health issue that we talk about is if, let's say, if the person is the parent, right? If the qualifying relative is a parent, or if the qualifying relative, is a parent, usually we're talking about someone who is a little bit more advanced age. If that's the case, we always ask, does your mother or father have osteoporosis or arthritis or bad knees? Can they move well, right? Do they require ongoing care, any sort of physical therapy, or is there a possible surgery coming along the road? These are all questions we ask. We also ask, sometimes we get, oh, I'm perfect, there's nothing wrong with me. And then I start asking, well, have you had an annual exam lately? Oh yeah, I'm anemic, I forgot about that. Or, oh yeah, I forgot to tell you that I had a client who told me she was completely well, and then told me, last year I did have cancer and radiation and chemotherapy, but I'm fine now. So, if you have had a serious health problem in the past, and that problem also requires, constant communication with your doctor, going to check and to make sure that you continue to be in remission, these are important things you may want to tell your immigration attorney, because this is evidence that your health can be, can be affected severely if you have to go live in another country, or if you have to be here without that person who has cared for you in the past, right? We've had clients who have back problems that give them flare-ups, right? I had a client who told me, well, I go 2-3 months where I'm totally fine, and then I have very debilitating flare-ups where I'm in bed. My spouse needs to bathe me, care for me, seriously, restroom issues. My spouse takes care of me in all of that. If that's the case, of course we submitted evidence of the person having scoliosis, the effects of the flare-ups, what type of medication they were under. Even if you're not under any medication, but again, like I said, you have something that maybe comes back, you get flare-ups for a certain condition. We had a client who was about to undergo hand surgery, also was going to get some sort of surgery in this area. I don't remember what it's called, but they were getting surgery there because they had an accident a few years back at work, and it just wasn't feeling any better. Anything that could possibly be related to health, high blood pressure, diabetes, cholesterol, any health problem, you need to really sit down and think about what health problem can my qualifying relative have, or what health problem will I have if my spouse is separated. And then make sure in that affidavit, again, the value of doing a correctly written affidavit is just so, I cannot stress it. You need to be able to connect how the foreign national, how does your husband or your wife or your child or your son, daughter, how do they help you, the qualifying relative, with this health condition? Do they take you to the doctor? Do they cook a special meal for you? I've had a lot of waivers where my client is diabetic, and they require special diets, right? They have some people have type 1 diabetes, and they need to have their insulin, and that person gets them their insulin or does their injections. Some people tell me, well, my wife puts me on a very special diet. I mean, I'm on a very special diet, and my wife cooks for me my special food. Make sure you explain all of that. It's not sufficient to just explain what type of hardship, what type of health problem you have, but it's important to connect that to how that qualifying relative, how that foreign national, right? How your husband or wife, how do they help you when you have that health problem, right? If you have a health problem and your spouse cannot help you or doesn't help you, then that doesn't help the case, right? Make sure that you explain any health condition and how you really depend on that person to help you when you experience the panic attack, when you experience the flare-ups where you cannot move or go to the restroom. I had a client with fibromyalgia, you know, who tells me when I have flare-ups, I cannot move at all. I have to be in bed the whole time. So explain, you know, how your spouse gets you out of bed, how your spouse cooks for you, how your spouse takes care of their children when you are incapacitated. We've had a client that had, you know, a lot of eye problems and was in high risk of going blind. How that health condition can really be exacerbated if they had to go abroad where they don't have these special eye doctors, or if the person had to stay here and their vision has deteriorated to a point where they're already blind, right? So there's a lot to really explore. To me, this is the most important factor that a USCIS looks at. USCIS looked at in 2013, and USCIS is really determining cases a lot by the health factor. So don't ignore that. Please make sure you take a long time thinking about what health problems the qualifying relative may have. Everything, include everything. You know, I wish I could just take like an hour just talking about health. We've had clients with heart failure, or they are at very high risk of getting a heart attack or a second heart attack. They are at high risk for, you know, a stroke because they have really high blood pressure. If you're at high risk for a stroke and you have had a lot of ongoing like blood pressure problems, you know, that's the truth. If you're very close to getting a stroke and then your spouse gets taken away to another country, you know, that stress, and there is medical research to prove that that amount of stress and just fear and sadness of separation, these things really do impact, you know, someone's physical health, from stomach issues to strokes, heart attacks. These things are a big deal. So make sure you take a minute to really look at every single factor and connect that again. I wish I could just say this 100 times. Connect that to the way your foreign national spouse or child, son or daughter, how your foreign national son or daughter or your foreign national spouse help you cope with that problem. The next one, I would say this is the second, and this is also very important, not as important as health, but also very important, is financial considerations. So it says right here, for example, future employability, loss due to sale of home or business or termination of a professional practice, decline in standard of living, ability to recoup short-term losses, loss of care for family members, cost of extraordinary needs such as special education or training for children. So if the foreign national is living here and helping you, you know, I'm gonna say this one is very common for spouses. You say, well, you know, my husband, he works full-time, he maintains our home, we have a mortgage, we have car bills, we have car insurance notes, we have 3 children together. You know, if my husband were to have his case denied and he's, you know, stuck abroad, of course we will suffer because we will lose our home. We will lose childcare. We will not be able to pay for our cars. We can be homeless, you know. You need to make sure you take a good time to digest or to explain how financially you will, you as a qualifying relative will suffer extreme hardship. We had a client that the qualifying relative was earning a lot of money compared to the to the foreign national. And by a lot of money, I mean like the qualifying relative was earning like maybe 70,000 and the other person was earning like maybe 100,000. And immigration said, it was very interesting, the RFE said like, it doesn't look like, you know, you're really gonna suffer that much because you make more money than your husband. Which I thought was kind of funny that they just like blatantly said in the request for evidence, you know, we don't think you're going to suffer that much because it looks like you earn pretty good money. You know, that's not the factor. A financial consideration means when you're taking into account what the foreign national is bringing into you, to the home. If you depend on that money to survive, you know, then and that money is no longer going to be coming in because the visas gets denied, then, you know, extreme hardship, financial hardship should be assumed. So what did we do in this situation? We said we went back to the drawing board and we had a spreadsheet of every single bill they paid. And the reality was that, you know, this couple, they had 2 homes. They had a lot of bills. They had medical bills. This was like an older couple. They had a lot of pending medical bills. They had, you know, a mortgage. Like I said, they had this large debt. And the U.S. citizen was also close to retiring. So these are things that we needed to explain to USCIS. Here's the spreadsheet of the expenses. I really need my spouse's share of income, because if I don't have that, how am I going to be paying 2 mortgages? How am I going to be paying all these bills and all this debt I have, right? So it was an interesting question I also saw in one of the Facebook groups where someone was saying, well, I earn very good money. Is that going to make our case weaker because my husband earns a little bit less than I do? And the answer is not necessarily. Take a look at your bills. Take a look at all your expenses. If you don't need your spouse's income, then yeah, it could hurt you. But if you really do depend on that income coming in to cover childcare, to cover the home, to cover, you know, your car insurance, gas, you know, commuting money, you have to put all that in a spreadsheet and show immigration, hey, I depend on that money, or we depend on that money to keep the home afloat, right? There's another section here that talks about future employability. Now, what does that mean? We have a client who, and I love giving examples because I think once you start to see other people's scenarios, and you can kind of get ideas on how this can be applied to your case. So we had a client that was just finishing nursing school, right? And she says, I cannot go to my husband's country abroad. I don't speak Spanish well. I won't be able to be a nurse over there, right? I won't be able to be hired over there. As a matter of fact, when last time I went, I couldn't really even understand his family that well. So I know I will not be able to get a job if I move to his country, and if I have to live there, our finances will suffer extremely, right? Because I will not be able to get a job, and the only job he could get there was working in his family's farm. That's basically what that scenario was about. One thing I want to highlight here is the decline in standard of living. Now, we mentioned, remember, it doesn't matter how much money you make. If your standard of living is going to decline drastically, this is something that USCIS has stated they will take into consideration. Oops, I don't know what that is. If the qualifying relative, this is something we used for one of our cases. We had a client who, the qualifying relative was the parent, and the parent was already kind of about to enter into hospice. The mother was very sick, and they couldn't afford to have a full-time nurse, but they did have someone come and care for the mother 2-3 days a week, and that was getting paid by her son's job, right? Her son was working, and her son was the one that needed to go abroad and get this waiver approved. The mother was a qualifying relative. We showed that, you know, the qualifying relatives care, the people they were paying to care for her, that the money was coming from the son. The son was paying for her care. And so if the son's visa is going to be denied, then the mother's care will suffer, because they will not have that amount of money, or that money coming in from the son, or the son won't be able to pay that much money. And guys, I mean, this happens, you know, if the case gets denied and the person is stuck living abroad in like any country really besides a European country, if they're living in Latin America, that person is not going to earn anywhere near as much as it is required to send money to your parents here. We also, this same one we used, this same factor we did use for a client who the wife was a U.S. citizen and the husband was going to interview abroad, and the wife said, well, my father is very sick, and my father has to get dialysis 2 to 3 times a week, and my husband pays for part of that. Can I explain how that will affect my father-in-law or my father? And the answer is, that's technically, you know, the father-in-law is not a qualifying relative, but you can explain how, if you don't have your husband paying, so what we did, we told her, we can explain how, if your husband is not paying for your father's health care, that money is going to have to come out of the home budget, right? You may not be able to make all of the home payments because you're going to have to, because you care for your father who's on dialysis. So even if there is another family member that is sick, if you can connect that to the hardship of the qualifying relative, you can also think about using that in your affidavit. Another factor that immigration looks at is education. It says right here, for example, loss of opportunity for higher education, lower quality or limited scope of education options, disruption of current educational program, requirement to be educated in a foreign language or culture, with ensuing loss of time or grade, availability of special requirements such as training programs or internships in specific fields. So this is for those couples where, or for these situations where the U.S. citizen or permanent resident qualifying relative, they're still in school, they're getting training, and they say, if I were to have to move to, I don't know, Ecuador or Mexico or whatever other country to be with my spouse, you know, I'm not going to be able to continue my program because I don't speak the language, because they don't offer that program. And you can explain that here, right? We also have used this for a case where the qualifying relative, or the U.S. citizen spouse, she was saying, well, my husband is currently paying for me to finish my degree so that I can be, what do they call, a CSA, so that I could be like a medical assistant. So he's paying for my tuition now. If the case gets denied, you know, I'm not going to be able to continue going to school. I'm going to lose that money, and that is going to be under financial considerations. But, you know, if he's not going to continue paying for your school, then that can also be an education factor. There are also other factors to look at. It talks about close relatives in the United States. I always ask my qualifying relatives, and again, most of my qualifying relatives, sometimes they're U.S. citizen spouse, and I say, okay, well, you know, we'll make a name Mary. Okay, Mary, well, let's take a look, see here. Do you have any family member living in the U.S.? Like, can we explain that you cannot easily go abroad because you have family here? And a lot of times I hear, yeah, of course, my mom, my dad, my cousins, my tios, everybody is here. And, but you know, my sister is here too, and she currently is suffering from like stage 4 cancer. We had a case like that. And she's like, and I take my sister to chemotherapy all the time. My parents are here and they're very old, and so they're living with us at home. I couldn't leave. I couldn't go back to my husband's country because my father is on dialysis and he lives with us. So these issues, remember, if they can connect to the hardship of the qualifying relative, they technically fall also under personal considerations. One thing I've seen, and I want to take a little break and explain. You know, guys, these factors right here, they're not, a lot of them mix with each other. I've seen people ask, well, my affidavit is all over the place because I get this and this and that, and that's okay. You can have sections where you discuss health, financial, education, personal, and maybe personal will also coincide with financial. Maybe educational will also coincide with financial or personal, right? That's okay. So if you have another family member, if the U.S. citizen spouse has, you know, sick parents or another sick family member, or the U.S. citizen has disabled children, this is also a very important one that we have addressed. If the U.S. citizen wife has children here, and a child has ADHD or suffers from autism, right? Anything that requires that more care from the school, or maybe special education at the school, anything that requires just more individual attention. You need to make sure that you address that in your testimony, because I had a case where we filed an I-601A for a husband and wife, and the wife was telling me, you know, our daughter suffers from autism and she's 2 years old, and part of her condition is that she goes into these really, really long crying spells. And the only person that can ever get her to, you know, calm down and stop crying and feel less fear is my husband, who is the person that's gonna need the waiver, right? And we explained that to immigration. And I know I said in the beginning that if you have a child, that your child cannot be your qualifying relative, and that's true. But if you are the mother of that child and you're the qualifying relative, you need to make sure you connect that, you know, I need my husband here. I need him here because he gives our autistic child that support, right? And if he's not here and I'm stuck here in the U.S., not able to care for my child, that's going to affect me too. It's going to affect me emotionally. It's going to affect me physically, you know. Of course I'm going to suffer more than any regular person. I have a child with special needs, right? And submit those documents that you have a child with special needs, because obviously that is going to affect you. So if you have an attorney that says whatever your children suffer, that doesn't count, that's not true. If your child is going to suffer something, that still needs to be connected to you, right? You cannot say, my children will cry without their father. You need to explain, how does the children crying without their father affect you, right? As the parent, as the qualifying relative. So I hope I didn't take too long to say that, but it's important. There's another section here that we sometimes talk about other factors, right? Special factors, like what cultural factors can affect a case, and this is for our language barriers, right? If you are a U.S. citizen spouse and you're the one that's a qualifying relative, and say, you know, I cannot go back to my husband's country because, you know, my husband is another religion than I am, and if we go to that country, we can be in serious trouble. That's something very important to say, right? There are some countries where only certain religions are tolerated, and if you are either a mixed race, a mixed religion couple, you know, you can face severe persecution. Your life can be endangered. You need to explain that. If there are going to, so these special factors, they talk about cultural factors, language. If you don't speak that language, harp on that. It's very important. You know, USCIS cannot really expect you not to suffer hardship if you go to a country where you cannot communicate with anyone. Religious is very important. If you're both from different religions and that's not tolerated in that country, you know, that could put your life in risk or in danger. Any ethnic obstacles, you know, there are certain countries where there are ethnic minorities that are persecuted. I don't want to name any countries, but there are. And I talked here about valid fears of persecution or physical harm. If your spouse's country is in one of these countries that is currently undergoing a lot of political turmoil, and really I can mention almost any country right now, anything in Central America, anything in Mexico, Central America, South America, a lot of countries right now are going through a lot of political turmoil. There is a heightened violence. Mention that, you know, safety is important, and that's something that if you go and live abroad, if your life and safety are at risk, how will that affect you going to that country, right? But we do, if you go to the State Department website, travel.state.gov, and you can look at you can look for the country you know of your foreign national. Like, you can see if the State Department has put out a travel warning or has warned people against traveling to certain countries or certain parts of that country. You can include that evidence and say, hey, look, we're going to be going to a very dangerous area. Obviously, if we go there, that's going to affect me. It says statements and explanations should be supported by evidence. Merely stating that your U.S. citizen's spouse or parent will suffer extreme hardship is not enough to meet the burden of proof. And this is true, right? If you say you have a health problem like osteoporosis or arthritis or diabetes or whatever, you need to back that statement up with documentation from your doctor. You need to back up every statement you make, whether it's financial statements, proof of your taxes you filed together, proof of the bills you pay, right? When we talked about health here, and we said, you know, any health issue, any sort of even mental health problem, you need to have a letter by your therapist. You may need to have a full psychosocial evaluation submitted. Psychosocial evaluations are scrutinized a lot by USCIS, and sometimes USCIS doesn't give them a lot of weight. You need to make sure that you talk to your therapist and that your lawyer takes a look at that report, because sometimes you just get like a one letter that doesn't say much. If you're gonna request that your therapist give you a full psychosocial evaluation, it needs to talk about the qualifying relative's ongoing mental health problems, not how the qualifying relative is simply going to suffer, or I've seen reports where it's just like scared of husband being deported. You know, that's not really, and this is kind of maybe a little bit of an off track, and I don't want to say the wrong thing, but the therapist is supposed to explain what ongoing mental health problems you have suffered. When did you start suffering these mental health issues? How did these mental health issues come about? You know, how have you been coping with it? How often have you been going to therapy? Are you under any medication? You know, immigration has stated in this one example that I was mentioning earlier, where the person tried to kind of copy your case and then they got a notice of intent to deny. Immigration said the report you you submitted says that you're just scared of your husband being deported. And when I talked to this client, you know, she told me, oh, I've had mental health problems since I was a child, you know, and none of that was in the report. That was not in the report. The report talked about just what will happen if the husband is deported or the case isn't approved, right? That's not what your mental health therapist needs to be writing in a report. So that's also something, I mean, I didn't want to take too much time to explain that, but the quality of the report is very important. It really needs to focus on what the therapist does, right? When were you diagnosed? How has this diagnosis come about? Do you get angry spells? Do you get, you know, panic attacks? Have you just been lost, you know, like, and I had someone who, when they suffered a panic attack, also kind of like lost, you know, sense of where they were. Have you had, like, has the qualifying relative had suicidal thoughts? And when it comes to explaining how their treatment, or how that, you know, they get a little bit better, or how they're coping with their mental health problem, the therapist can explain how the foreign national, or the husband, wife, how they help this U.S. citizen, right? The therapist can say, you know, so-and-so, we'll just use the name Mary, I don't know, Mary has been suffering for, you know, 25 years. She's been suffering from anxiety, panic attacks, depression, and when she has these panic attacks, she has informed me that her husband is usually there to comfort her. Her husband is usually knows how to make her feel better and get out of one of these attacks. She has mentioned that she has had suicidal thoughts, and the husband can really talk her out of these feelings, right? Has been able to really talk her out of feeling really low and depressed. That's what the therapist report is for. Explain what you have been suffering in the past, and how maybe your spouse makes it better. Not to just say you're gonna suffer, or you're gonna get anxiety if the visa gets denied, or you've been having anxiety only as of yesterday, thinking about this case, right? They're not gonna give that a lot of weight. And I have had, like I said, I have seen many reports just talk about only the immigration thing, and I'm just like, you know, that's not your job. As a therapist, that's not your job. Your job is to talk about the person's history, and then if you want, you can make a connection on how the spouse or that foreign national helps them. And if you're working with a therapist that doesn't understand that, perhaps you need to see another therapist, or you need to make sure that you tell the therapist that the person you have been going for many years to see, you know, for them to not discuss that, because that's really outside of the scope of what they should be doing anyway. But yeah, I've seen some weird reports, and I think that's the reason why USCIS gives them less weight. They can give a report very good weight if it's well written, right? Your testimony can be very important if it's well written. Your therapist report can be very important if it's well written. The art of having something well written and well explained, it really can make a difference between an approval and a denial. So for those of you who are working with an attorney, make sure you trust that attorney, and make sure you push that attorney to really look at your testimony, and make sure that anything that's unclear in your affidavit or testimony, that's, you know, looked at and corrected. What I want to say about, you know, me being in so many Facebook groups and seeing things is that I saw someone say that their attorney told them to write the letter on their own. Just explain how you will suffer without your spouse. And this may get me in trouble with some colleagues, but I don't think that's very good lawyering. I think that if your attorney tells you, write down how you will suffer, so that when we meet, we have so that when you and I meet, we have kind of a roadmap to follow in the creation or the writing of your affidavit, then that's okay. But if the lawyer wants you to just write the letter on your own, I would really be hesitant to want to go forward with that attorney. And again, this may get me in trouble with some colleagues, but I really think that someone who doesn't know the law well and someone who doesn't do this every day, I have never seen someone write an affidavit that touches all the points that we're discussing here. I mean, maybe if you watch my video, you may be able to write a really solid affidavit, but I want to be clear that, you know, these affidavits are scrutinized a lot, and what you say in page 10 can hurt you later because you said something else in page 1 or 2. And so you really need someone that works in these cases and knows what does immigration want, what does immigration not want, what does the therapist report, what should a therapist report focus on and not focus on. Now, when we talked about financial evidence, if you're going to say you have 2 mortgages, you better have your mortgage statements. Car payments, you better have those statements in there. You say you're going to school for nursing, submit that transcript. You say that, you know, you cannot speak the language, or that you and your spouse are different from different religious backgrounds, and you each go to a different church or mosque or synagogue, whatever it is. If you can get letters, you know, in support of that, then go ahead and file that too. If you have medical debts, any sort of debts you have had in the past, medical debts are very important. Expert opinions. You know what? I've never filed an expert opinion letter on a 601A waiver. I find this to be kind of weird. This thing here talks about what evidence you can submit, and we said, you know, pay stubs. You can submit your pay stubs and your spouse's pay stubs if you want to show their income and how you support them. You need that income to pay your monthly, you know, utilities or bills or whatever. The most important part here is to submit your taxes, really. You should be filing your taxes jointly if you're married, and you should submit those taxes to USCIS. If you have children together, submit proof that you have children together, like birth certificates. Even if you don't have children together, if you have minor children and you're married, then that person becomes your child, right? It's a stepchild. So submit those birth certificates too. Now, everything we've gone around, I know we already passed the 1 hour mark. Everything that we've gone through, not everybody hits every factor. Have we had cases approved without health? Yes, we have had cases approved without any sort of health problem. But we like to really see if we can include any sort of health issue if the person has it. Have we had cases approved, you know, with only one thing or another? Yes, we have. But you know, everybody's case is different. Everybody has a different background, different life. Some people come from, you know, very close families and they have a big network of support, and some people don't have that. And having a large network of support can be helpful if your parents who are here are, you know, older and you need to stay here for them. But not having a network of support can also help you, because, you know, you're going to be here alone without anyone to support you if your spouse is abroad. So you have to kind of be creative in the way you formulate your testimony. But also, you know, be honest with yourself. How will you really suffer? I get a lot of people who sometimes tell me at the beginning, oh, I don't know how I'll suffer. I'm okay financially and health-wise. And then, you know, 2 appointments later, I find out that this person suffered some really serious, like, childhood trauma that they're trying to overcome. And so in the first appointment, I always sometimes meet people that give me this front, right? Not really wanting to tell me everything about their life. this type of case, you need to be very vulnerable. As a qualifying relative, you need to be vulnerable. You need to show why you need that person to be here with you, right? This is not the time to say everything is perfect in my life, because because immigration has very little to go off of, right? Except whatever you submit. So what happens when you submit this documentation and immigration comes back a few months later and says they want more evidence? If that happens, go back and take a look very carefully at the request for evidence and see what they want. Do they want more financial stuff? Do they want more explanation on an affidavit? Don't give up if you get an RFE. I'm an attorney and we get RFEs. Not all the time, but we get RFEs with some of the waivers. And when we get RFEs, we tell the client, we really need to draft a new affidavit. We need to see what else we can find to show this issue that they're having, question about. And we file the case and we reply. So if you get a request for evidence, submit evidence. A lot of times the case is going to be okay and you're going to be approved. Now, that's been in our scenario, right? We know what immigration asks and we don't give them any more, but we also don't avoid submitting good evidence. So most of the times we are okay because we know what they require. And in reality, if a person has a perfect case, I mean a terrible case really, and they will never suffer and they will not suffer, I will be honest with them in my evaluation and I will say I don't think that that there is much. If there's no hardship that you can think of, and we talk about these points, if there is nothing that you can think of to submit with your waiver, then there's only so much I can do as your attorney, and perhaps maybe this is not the best time to file this for you. So, go over these factors, think about what you can submit to immigration. If you think that, you just got married yesterday and there really isn't absolutely anything in here that you can provide your attorney, perhaps you should talk to your attorney about that before you hire your attorney, right? But there is a lot that you can do to file a 601A waiver. There are a lot of factors that immigration looks at. The reality is that a lot of countries, especially in Latin America, they are going through a lot of turmoil. They're going through a lot of financial difficulties. Let's not forget, guys, we are in this middle of a freaking coronavirus pandemic, right? How does that affect your case? Well, it can affect a lot if your spouse is the only one working, or it can affect a lot if that country has a very high COVID exposure and they have very bad medical systems. So can COVID help my case? It can. You have to really think about, where is my husband or son or daughter from? Where are they? Where's my husband? Parents know all that. Where's my husband from? How is COVID affecting their country? And will I be affected extremely if I have to go live over there, or if my husband is over there and gets sick, right? So let me take a look at the other questions just before I forget. I don't want to make this, I know I told you this was really for the people who wanted to be experts in this case, and you were in for the long haul. Should I get a lawyer? This is a question that I see a lot in some of the groups. We help people, as attorneys I can tell you, we help people who are young and are technology savvy, but they are terrible writers and don't know the law. And we also help people who say, you know what, I don't have the time to investigate. What do I need to do? How does the 601A waiver look at that? And so we have clients that hire us from the beginning to the end. You will know if you need a lawyer, right? If you are with me at the 1 hour and 12-minute mark and you have looked at everything and are taking notes, and you have at least contacted an attorney to make sure that your spouse or that you do qualify for this waiver, you may not need one and you may be able to do it alone. But, you know, if you feel like this is all these factors you're talking about and this affidavit is looking like a lot for me, maybe it's worth getting an attorney. It's really your call. I think deep down you won't know. One thing I do want to say is, you know, think about the value of getting a permanent resident status, right, and not having your case denied. This type of case takes 2 years, 2 to even 3 years, depending on where you're going to interview abroad. If your case is going to be called to interview in Ecuador, you may wait maybe a little bit under 2 years from beginning to end. But if your case is going to be in Mexico, you may end up waiting 3 years because that consulate is the busiest consulate in the world. And the wait time is about 1 year after the waiver gets approved. So if you're going to if you want to get started on this track and you're saying this is the time for my husband, my wife to get their green card and we're going to petition for them and we're going to do the waiver, the waiver can take about 9 to 12 months to be approved or denied. And if you do get denied, I mean, you're going to have to start all over again and file it again, you know. So it's your call. Do you want to do it with an attorney? Do you not want to do it with an attorney? That's up to you. If you get an attorney, okay, and I may be hated by some attorneys here, make sure that you get an attorney that really knows what they're doing with this type of case. There are people who are not immigration only attorneys and they do bankruptcies, divorces, they do, you know, traffic tickets, they do every sort of law, and then they submit very, very deficient packets. I had someone come to me, and this is really weird. They got denied, they got their waiver denied, and they worked with they worked with a large immigration law firm, like a big immigration law firm here in New York City. And whoever did the case, they didn't even submit an affidavit in support. They just wrote, like, in the little I-601A form, they just filled out a few sentences why their spouse would suffer hardship without them. And I was just shocked. I said, you didn't have an affidavit in support? And I said, no, we didn't know. This is just what the lawyer sent. You know, you need to make sure that if you get a lawyer, you have very good communication with that attorney, that attorney sits with you, goes over all the evidence that you need, and that you have a plan of action. What evidence am I going to submit? And that your attorney reviews your affidavit with you. That either you and your attorney draft the affidavit together, but the attorney reviews your affidavit and helps you organize it in a way that it's clear. So the value of a lawyer is high, but you also need to be in the right hands of the right lawyer, not just any lawyer. What happens after my waiver gets approved? Okay, so once your waiver gets approved, you have to at the same time be working with the National Visa Center on this portal, the SEAC portal. And once the waiver is approved, they send information to the National Visa Center and let them know that the I-601A is approved. If at that point you have submitted everything you need to have your interview scheduled, then NVC will let you know that you are on queue to receive your interview from the U.S. consulate of your home country or of the foreign national's home country. What happens if my waiver is denied? Well, look, if your waiver is denied, that doesn't mean you can never get a green card again. To be honest with you, I spoke to an attorney, he's a good friend of mine, and he said, you know, we had a waiver denied and it was so weird because it was a really good case. And what we did was we filed the waiver again, the exact same waiver, we filed it all over again, and it's the second time it was approved without an RFE, without a request for more evidence. So if your waiver gets denied, don't be discouraged. You know, take it in stride. Don't say, you know, this sucks, I'm never gonna get my green card, or my spouse is never gonna get their status. Don't think that way. Think about, let me take a step back, let me see what was not filed properly, or maybe what was insufficient. What can I do to improve my waiver? And if everything is fine and your attorney tells you and you are in good hands and the attorney says, let's just file it the way it is, hey, I'm telling you, it can be approved again. It can be approved. When will I go abroad for my interview, and will I really get my green card there? you don't get your green card when you go abroad. So when the consulate sends you your appointment and tells you you're ready to go and interview abroad, you get, you will take a list of documents that the consulate sends you, or you can find abroad, online. I'm also going to do another video which talks about everything you need to take with you to your interview abroad. When you go there, the consulate, what they do, the officer will stamp a visa on your passport, and that's called an immigrant visa. That visa will say in the very bottom that you have been granted a waiver, and that waiver is called 212A waiver, meaning you got any unlawful presence punishment removed, right? And when you get your visa on your passport, you come into the United States and you give the immigration officer a packet that you brought with you from the consulate. So this packet is going to be like in a black plastic bag, and it says do not open. You give that to the officer, and basically it's like your affidavit of support and other documents. And then the officer says, welcome to America, and they stamp your passport. And once you come in, you can pay a $120 immigrant visa fee, like this registration fee, or you can pay it when you're abroad before you come here. But really, all of our clients, we tell them, just when you get here, swing by the office so we can, give you your congratulations mug. And we have these yellow mugs we give our clients once they get their green card approved or citizenship approved. And there is where we help them file the payment online. When you make the payment, you usually get your green card in about 6 weeks. It could be as little as 4 weeks. It could be as long as 1 year, okay? I'm giving you an average amount of time after you pay that fee. Now, why is it 1 year? I don't know. We had a client that he really did have to wait almost a year to get his green card for some weird reason. Most cases are 6 weeks, but it can go up to a year. We called USCIS multiple times and they said, well, ma'am, he gets a 1 year stamp because we have 1 year to give him a green card or to send the green card if required. So maybe it could be that the service center is really busy. I didn't really buy that, but I'm letting you know, most cases it takes about 4 to 6 weeks after you make that payment and you come in to get the green card in the mail, and you will tell immigration where you want your green card when you file your DS-260 form, and that's going to be all in that other video. This video is long enough. Last question. And really congratulations to you. If you watched me all the way through, please send me a message, and if I can, I will see if I can send you some sort of congratulations mug. Is there a way to not leave the United States for my green card? I get this question all the time, and I just had to throw it in here. If you came, and we have made a determination that you came without inspection, and that and that you have to go abroad, this is based on only evaluating a petition based by your spouse, right? There may be, if you talk to your attorney, there are other ways that you may qualify even if to get your green card here, even if you came without inspection. If your parents are U.S. citizens or permanent residents, you may want to tell your attorney, hey, how did they get their green card? Did they get their green card because there was a law called 245I? Could you perhaps be grandfathered under that law? If you're grandfathered under that law, then maybe your spouse gets to petition for you. You just have to pay a $1,000 fine and stay here, right? So 245I is the answer. That's another way. Now, if you have been a victim of of abuse by your spouse or your U.S. citizen child that's over 21, you may want to take a look at our VAWA video and see why maybe VAWA is better for you. That's another way you can get your green card in the United States without having to leave the U.S. and go abroad. So there may be other ways, but there's no way you can do this waiver and get your interview here, right, under this type of case. So the answer is maybe. I had a friend that gifted me a book called Getting to Maybe, before I went to law school, because sometimes the answer is maybe, and you need to feel comfortable with that. It depends on your specific circumstance. Well, guys, I don't want to take up any more time. This is a lot. I'm tired. My throat hurts. I hope that whoever made it to the end of this video got a lot of information, got a lot of questions answered. If you want me to evaluate your case, you can go to my website, alvarez'immigration.com, and there is a place where you can book a consult. You can also click on the link below, and we can talk about your case in more detail. Make sure you remember, before you start doing anything on your own, make sure that the person actually qualifies for this waiver, because I have had to make very unfortunate calls from people that hire me to do a background check on them, and it turns out that they were in fact order deported 20 years ago, and I have to give them that call and say, I'm so sorry. It turns out that when you were caught in the border, that it was not a voluntary return, that it was in fact a deportation. And if it was a deportation, you know, coming back without permission, right now, the way the law is, you cannot get any sort of green card through this program. And you know what? That's valuable to know. It's important to know that you don't qualify, because the last thing you want is to go abroad and be stuck out there and have your case denied, right? So be truthful with your lawyer about any stops that you have had in the border. Make sure your lawyer knows how to check your record. Make sure your lawyer is not just sending a FOIA with USCIS. Make sure that your lawyer is sending a FOIA with OBIN, right? A fingerprint check. If your name is very common, nothing may come up, but maybe with your fingerprint something will come up, right? These are very important things to really make sure that your lawyer is aware of this program, and that they know all the nooks and crannies, how to investigate if you've been stopped abroad. I mean, if you've been stopped at the border, how are they going to investigate whether you got order deported or not? And sometimes lawyers tell people nothing came up, but something really is there, right? That's really scary. You know, so sometimes the best checkup is a fingerprint checkup, and those checkups may take a little bit longer, but knowing that you actually qualify before you leave and are stuck out there is very valuable. Again, thank you so much for staying with me. Feel free to visit me again, alvarez'immigration.com, and I hope to see you soon in our next video. Bye-bye.